Hello, Tan Sri Hishamuddin Muhammad Yunus, Tan Sri Zahara Ibrahim, and Tan Sri Azhar Muhammad. All three of you, Bengkulu judges of the Court of Appeal, have become criminals by your own ignorance of the law. I still say you did not know that Section 166, Section 217, Section 218, and Section 219 exists as a check on the abuse of power, as a check against corrupt practices. Well, regardless of whether you realize it or not, you have breached the law, and ignorance of the law, everybody knows, is no defense. Now that I've discussed this, these four sections related to their application tempered by the law inequity called Audi Alteram Partem, which I discussed last night. It merely means both sides must be heard. Plaintiff and defendant both must be heard before the judge can decide legitimately. Well, in the case of Court of Appeal, through their ignorance, maybe is the ignorance of the English language is possible, or more likely ignorance of the law, they, by their action in awarding damages to Lim and Ho in the sum of $600,000 and costs against me for $40,000 without any evidence adduced, whether from the level of the court of first instance before Judge Zabaria, nor were there any evidence available to the Court of Appeal managed by these three Bengkulu judges of the Court of Appeal. They did not have a shred of evidence, both regarding proof by Lim and Ho that they suffered damage arising from my statements made against them, and for all intents and purposes, they brought a witness to support their claim for damages, who in actual fact gave evidence in my favor. So, in this situation, as I had earlier set out, there are only two options open to the Court of Appeal in the light of the bedrock, cornerstone of English common law and equity, the principle of Audi Alteram Partem. If you take away the principle and the working of Audi Alteram Partem, it simply means there is no English common law and equity in operation. you may as well bring in Sharia, because that, in the context, if and in the absence of the principle of odi authorum partem, there is no common law. There is no English common law. It is nonsense. It's blatant nonsense. And these three Bengkulu judges did not know that they could not, by any stretch of imagination, able to act as they did to award damages against me in the absence of any evidence to prove that my statements against Lim and Ho caused damage to Lim and Ho. So that said, I have instructed my solicitors to file an appeal to the federal court on the basis of what so far I have stated. And I will display my appeal on the pages of Facebook so that nobody will miss it. And this is what I wish to tell you, what possible action that the federal court can take. What possible action at all can the federal court take? In the first place, the judges cannot affirm or endorse the judgment of the Court of Appeal. Why? Why can't they do that? They've been doing a lot of funny things. Why not this time? It is because if the Federal Court of Malaysia endorses the judgment of the Court of Appeal in my case, then in actual fact, the Federal Court would have declared that English common law and equity does not apply in the courts of Malaysia. It will be shameful, and Malaysia will be the laughing stock of the world. I mean, that is not unusual, but that's what exactly will happen, because it's a nonsense judgment for the federal court to affirm the judgment of the Court of Appeal. Now the second point, because I raised it earlier yesterday, that if the federal court dismisses the judgment of the Court of Appeal, the federal court will in effect declare that the three Bengkulu judges of the Court of Appeal have breached Section 166, Section 217, 218 and 219, of which 219 carries a maximum jail sentence of 7 years. I have said again, are the judges of the Court of Appeal, are they brave enough to do that? I doubt it. I mean, Malaysian judges do not have the conviction of principle. They're not committed to the sanctity of the law. They will trash the law in any way that they care to do, and that also goes for the federal court. I have no doubt whatsoever that the federal court will find a way, one way or another, to try and rescue the three Bengkulu judges who have in actual fact, in every sense of the word, committed breaches of the sections which I have repeated so often. I don't think they will do it. So, what is the likelihood of the action of the federal court when my appeal goes up to them? I think in all probability, the most likely course of action that they will take is to render the judgment of the Court of Appeal as null and void ab initio. In other words, from the very beginning, the judgment, including Judge Zabaria's, will be null and void, because they will seize upon our submission that Lim and Ho, being only a firm name, does not exist in law. Lim and Ho does not have legal persona to act in their own right as plaintiff of the action. This is the most likely one, because in doing that, they need not consider the illegal, unlawful, criminal conduct of the judges of the Court of Appeal. Tan Sri Hishamuddin Muhammad Yunus, Tan Sri Zahara Ibrahim, and Tan Sri Azhar Muhammad. All these three Bengkulu judges have made themselves criminals because they did not understand the consequences of their action. I will bet you $1 or ringgit that the Federal Court of Appeal will choose to take the action to void the whole judicial process. And the only way to do that, I believe, well, anyway, if I'm wrong, it's okay, because from 1987 up to now, I have not read a single law book. All the law that I believe is the law is from my memory days when I studied law at the University of Singapore. When you study in a good university, your knowledge, your training stays with you, like as if you learn to ride a bicycle. Even as late as 80 years, I can still ride a bicycle now, although I haven't ridden a bicycle in maybe 50 years, 60 years maybe, but I can still jump on a bicycle now and ride off, So, that's how the situation is. I will say the judges of the federal court have very little room to maneuver. And above everything else, they do not have the powers, the jurisdiction, whatever. They cannot affirm the Court of Appeal. If they affirm the Court of Appeal, then Malaysia cannot use English common law and equity. You may as well scrap that and introduce Sharia court, which is more appropriate to Malaysia, because your judges, your lawyers, they hardly know any damn English at all. Anyway, that is my message for today. I'll speak to you again. Good night.